Hi. Good morning. Today is Monday, November 17th, 2025, and this is my first live, so I'm a little nervous. Be patient with me. Today, I wanted to talk a little bit more about Aaron Spencer's case. But first, at more, let me, let me rephrase that. Today, I want to talk about Aaron Spencer's judge, Miss Judge Elmore. And the type of history that she has as a judge, um, kind of a pattern that I'm noticing. And so, to transition into that, we're going to talk about the latest scandal, which is a 19-year-old young man was recently arrested for grape. And the thing that makes that stand out so much, and the reason why there's so much controversy and protest going on around that case is because he was out on bail for grape. And guess who granted that bail? You got it, Judge Elmore. Again. So that's, Fossler, who was out on a low bail and reoffended, right? With the same victim. And now we have a 19-year-old out on bail for the same types of crime. In fact, I think this kid had 11 felony counts, and he was let out on bail and reoffended for the same, you know, for the same thing, and was arrested. So it seems to be a little bit of a pattern with her. I don't know why she sympathizes with these defendants so much. But it seems as though she does. Seems as though she's got like a soft spot for them or something. So I went down the rabbit hole and dove in and tried to do some research on her to see what kind of judge she is. Is this regular? Is this a pattern? Does she do this often? And I found out some interesting things about this judge, and I'm not quite sure what to make of it. I don't know if she's just not that great of a judge, or if she has poor instincts, poor judgment, or if she just doesn't give a shit. Who knows? Especially in today's day and age, right? But I tell you what, she doesn't have a soft spot for Aaron Spencer. For some reason, he doesn't seem to make it on her radar. I mean, he had a pretty big bail compared to the other two. And she wanted to uh, put a gag order on his case, which she did put a gag order on his case, and it was overruled by the appellate court. So luckily, there's that. Although she waited a few months before she put it into effect, which I don't know how that's even legal, but I guess who's going to challenge a judge, right? Anyways, she seems to get appealed a lot. And I've noticed that her appeals, or not her appeals, the defendant's appeals tend to get honored. I mean, she's had some reversals. So I'm not quite sure what to make of that. She also ran for DA in, let me see. She ran for DA in 1998 and lost by one vote. Literally one vote. I mean, I don't know why I'm laughing at that, but that sounds like something that would happen to me. Literally, I would lose by 1 vote. I don't know. But, yeah, so kinda interesting to read up on her history. So we're gonna go over that and see what you guys think about it. Um, so let's dive in, shall we? I have to now this is the first live, people, so please be patient with me. Please, please, please. Leonard. Now the young man who was um, on bail for grape that reoffended, his name is Wesley Hennard. And I tell you, this guy, he does not look 19. He looks like he's in his 30s. I'm not even kidding. He Let me see if I can find a picture of him. He literally looks like he's 30 something years old. This is him. Let me show you. Oh my gosh. Just 1 second, guys. I have to prove that I'm not a robot. Okay. Man, okay. Why is that so small? Okay. So this is Wesley Richard Hennard's booking photo. Now tell me this guy does not look like he's in his 30s. Does he look 19 to you? He doesn't look 19 to me. He's got a Jeffrey Dahmer vibe going, you know, with the glasses and everything. I don't know. I just, uh, yeah. Anyway, that's who we're going to be talking about today. So, just 1 second. Couldn't see my button. Okay. So, that's the 19-year-old who reoffended while he was out on bail. And Judge Elmore is the one who let him out on bail. Okay. Sorry. Give me just a second. No, no. Must be a pretty common name because there's a professional disc golfer that named Wesley Hennard. There's all kinds of guys named Wesley Hennard. Weird, right? Um, so what happened to my article? I'm sorry, you guys. Just be patient. Just Okay. Hennard, Wesley, Richard, Lonoke County, Arkansas, 10/31/25. Is it showing up? Nope, sorry. What am I thinking? My bad. Is it showing up now? Sorry, you guys, I'm trying. I don't want it that big. How can we fix this? I'm so sorry. Maybe I wasn't ready to go live yet. You think? I'm starting to think that. It won't let me scroll if I do it this way. I don't know why. Okay. It's so weird that it's not letting me scroll, but let's try this, okay? The information below has been gathered from the Lonoke County, Arkansas public database. No claims are made as to its veracity. If you believe that your name appears in error or is this the wrong? Oh, that's not even, never mind, that's not even the article. Oh my gosh. Holy shit. Breathe, Wendy, breathe, Wendy, breathe, Wendy. I hate these news sites that you click on the article that you wanna read, and if you it makes you subscribe, and if you don't, then it shows you the whole paper minus the article that you wanna read. It's insane. It's bullshit. It's like, "Come on, people, really? Is it that hard to let us look at your fricking paper?" I mean, it's not like I wanna resell it or anything, I just wanna look at it. Okay, so let's try something else, shall we? My bad. I had it already, I don't know what I did with it, but would you expect anything else? It's embarrassing. I knew that would happen. I knew I wasn't ready. But we're gonna try and, you know, mu just muddle through, and hopefully you guys aren't too irritated with me by the end to not come back again. I don't know why I'm not finding my article. Okay, let's see. Hard. Oh my gosh. Why is it just want everything just wants to show me his mugshot? It makes me wonder if she sealed this his file so that nobody could see it, because I gotta tell you, she sealed another case the day before it was even she even ruled on it in court. So it just makes me wonder if she didn't do the same here, because I all I'm seeing is mugshots, mugshots, mugshots. There's no article about his latest arrest. It's insane. Everything just says mugshot. Unbelievable. Okay, well, there's one other way we can do it. Let's see. Arkansas courts. I guess I can just show you his charges in the docket. How's that? We'll we'll show them. We will show them who we are. We can work around it. Okay. So I won't be able to read you the article about it, but this is his latest arrest, and I'm not sure. Um, Barbara Elmore. I'm not sure where the other case that he has is out of, because this is all from this latest arrest, I believe. Oh no, it's from February. So these are his original charges. I don't see new charges in here. Wow. But see, she doesn't make anything available to us except for discovery motions. Um, what's this? Is his bond revocation? Let me see. This was put into record on, where's the date? The surrender is done in the behalf of First Arkansas bail bonds. Oh, 10/29/25. So this was from his latest arrest. For sexual indecency with a $7,500 bond. Is that insane or what? Are you guys not seeing this? I'm sorry. My bad. I got a little carried away. So this is why is this so small? I don't get it. I don't know what's going on here. Let's see. Ah, why is this not? Sorry, guys. I don't know what's going on. Um, recording hotkeys, camera, layouts. Okay. Now let's try this again. Sorry. Nope, that's still not what I want. Cancel. Here. Why does that get so small? Oh, because I don't have anything showing it. Okay, here we go. So, there's nothing really to show. This was on October 31st, so this looks like a new bond, a new bail, because this was October 31st, and it says the amount. It's not saying he was revoked. So what the heck is going on? Let's see. Get rid of that. That was on, yeah, so okay, I'm lost. I'm lost. I'm lost. Scheduling order. Judge Barbara Elmore. Jury trial to start on 1/14/25. So this all should have happened already, right? Pretrial's 1/13/25. So that doesn't make any sense. But it says that it was scanned in on 11/5/25 or 11/3/25. So what? I don't get it. What the heck? Because she must be left-handed. The way she signs her name looks left-handed. 23rd, 1st Division. I don't know. This is something about the videotapes have to be returned to the prosecutor's office at the end of the trial. What's a pickup order? The Lonoke County Sheriff John Staley is hereby ordered and directed to ensure that Wesley Hennard, white male, date of birth, is secured from the Pope County Jail in Russellville, Arkansas, and transported to the Lonoke County Courthouse on the 3rd floor in Lonoke at 9 a.m. on November 3rd, 2025. It is so ordered. So that's for this case. I'm not quite sure. Maybe they wrote the wrong, maybe they meant to write 11. Anyway, sorry about this. Yeah, she let him out, and he reoffended, and you can't make this stuff up, guys. I'm telling you. Just like the Jesse Butler from where's he from? Oklahoma. He was let out on bail and reoffended while he was on bail, and he was 19. He was actually sentenced to 73 years in prison, but the judge said that he qualified for the youth offender because he was 17 at the time of the offense. So she let him walk. He was sentenced to a month, I think, of counseling and I think some community service or something like that as of such. Yeah, he went from a 73-year sentence in prison to a month of counseling and some community service. That wasn't Judge Elmore, but still, I mean, it's like, what the hell is going on with these kids? First of all, I mean, when I was in high school, I don't think anybody thought about raping girls. I mean, if they did, nobody ever heard about it. Um, it just it's insane. It blows my mind that these kids are even thinking that way. I mean, what is going on with the parents? Where are the parents? And the one in Jesse Butler's dad, or no, is it Wesley's dad? Jesse Butler's dad was a football coach, I believe, for OSU, or was it Wesley's dad? No, it was Butler's dad was a coach for OSU. So you got to wonder if that it didn't have something to do with it. He had some pull, some connections. Anyway, it blows me away that that's allowed to that they can go from a 73-year sentence to nothing. I mean, there are juvenile detention centers in Oklahoma, aren't there? I mean, why even I don't know. Why even I would be pissed if I was on a jury and we found somebody guilty and then the judge did that. But they didn't say it was a jury trial. I'm not sure, but it said that he was sentenced to 73 years. So I'm not quite sure I guess I worked last night as if you couldn't tell. Maybe doing my first live this morning was not the best idea that I've had because I'm not doing too well. I'm batting minus 1,000, I think. But anyway, um, okay, so here are his charges. At least we can go over those, right? Expand. So, count one, grape. That's pretty self-explanatory. Class Y felony. Count two, sexual indecency with a child. That's a Class D felony. Count three, electronic facilitation of CSA. That is a Class B felony. And these all happened on 2/28/25. Count four is electronic facilitation of CSA. Count five, same thing. 6, 7, 8, 9, 10, 11, 12, 13. He must just go to town on that computer, right? 14, 15, 16, 17, 18, 19. He's almost up to Fossler's number. 20, 21, 22. 22 counts. So he has 21 counts of electronic facilitation of CSA and 1 count of grape. And I believe why are there no special circumstances of the grape being on a minor? Oh, I'm sorry. How did I miss this? So charge 1 is grape, which is a class Y felony. Count 2 is sexual indecency with a child. And that's a class D felony. Oh, did I already say that? I did say that. So there's 20 counts of electronic facilitation of CSA. And how many did Fossler have? 43 or something like that? 43 felony counts. And this kid had 22 felony counts. I'm not sure what the difference in the classes are. Let me look that up because I'm interested to know. Difference in class felonies. Difference in class FELONI. Okay, so did I forget to show you guys all that? I'm so sorry. I'm not doing very well today. Like I said, this probably wasn't my smartest idea yet to do my first live after working all night and not sleeping. Hello, dude. I mean, it's like, come on, Wendy, be a little smarter than that. Okay. Let's blow it up a little bit. Okie dokie. Where am I? Okay. Difference in class felonies. The classification of felonies varies by state and that's great, and can be represented by letter grades or numbers. For example, in Texas, felonies are classified as class A, B, C, and D, with class A being the most serious and class being the least. What did I say his... So electronic facilitation is a B, and sexual indecency with a child is a D? How is that? This must go the other way because the grape is a class Y felony. So, and I would think that would be the most serious charge. So I'm thinking this one must be the opposite, where it, A is the least serious and D being the most, but they have a Y. I mean, Arkansas has a Y. So I'm not quite sure where that fits in. Let's see what a Y class felony is. What is a Y felony? Says a class Y felony is a serious criminal offense that typically carries severe penalties. These felonies are often reserved for grave crimes, such as, murder, aggravated assault, kidnapping, and certain drug trafficking offenses. The penalties for Class Y felonies can range from 10 years to life imprisonment without parole. Class Y felonies are characterized by their significant impact on individuals and society. Okay, so there's that. Okay, so since that didn't really work out for me, let's see what I can do. I don't know why this is doing that. Okay, we're just gonna wing it, I guess. I'm not sure why my studio thing is doing this, but it is what it is, right? Okay, so there's that. Anyway, let's move on to Judge Elmore, shall we? Um, yeah, let's just jump right into it. There's no sense in, you know, prolonging this live any longer than we need to. I don't want to make you guys suffer any more than you've already suffered now. Okay. I appreciate you guys being patient, if I even have anybody out there watching. But if I don't, that's okay too. Gotta start somewhere, right? Anyway, let me see. Okay, the first one is okay, let me see. I can't even read my own writing. Okay. And this is Daniels or Douglas? Douglas. Okay, and the first case we're going to talk about that she had appealed is against Douglas, and he was on trial for battery, and apparently she had some kind of connection to, a prior case where he lost custody of his kids, and she was involved in that case. So they asked for her recusal, and she refused, and so it went all the way up to the Supreme Court. But why am I not finding anything now? This is crazy. Okay, there's one of them, but I wanna go in order. I don't wanna start at the last rung of the ladder where, it ended where the final decision was made. I wanna go through some of the steps of what the decision-making process was. This is crazy. I don't know what's going on. Okay, well, um, Judge Elmore slash D oops, Douglas appeal. Okay. It's almost like they knew I was looking this up all, and so they're hiding it all from me now. Feel like am I being like a total conspiracy theory nutbag? Probably, but I mean, what else am I supposed to think, right? This is crazy. Okay, well then okay, we're gonna get here, guys, I swear. Get here. Judge. Okay. Oh my gosh. What time is that? No, 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 no. Okay, so there's that. Oh my gosh, I'm gonna have an anxiety attack. I really am. Okay, so we'll just start where I can find one. How's that? I mean, I don't even know what to do. Judge Robert Elmore, House Appeal. Okay, well, I'm gonna have to go with this one, I guess. Just kind of start in the middle, and you're not gonna know what the hell I'm talking about, but it is what it is. And this isn't even the right person. Oh my gosh. I think I have this one written down though too, so I'll just have to start with this one. History. Okay. So I'll try looking that up because that's how I'll phrase it the same way I did earlier. Maybe I'll find it that way. Otherwise, we'll just start with what I have. Okay. 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 The first one is she seems to have her hands in a lot of different court cases, like a lot of like juvenile, um, civil, um, family court, criminal court. And so when she comes, and it's a small county, so when she comes across the same defendant in a different court, these defendants are requesting her recusal and she's refusing to. So it's causing a lot of appeals on her cases. This is Arkansas Court of Appeals, Jacqueline Ferguson versus State of Arkansas. Um, and this one was affirmed. So this one passed. It says, oh wait, let me share my stream. I mean, share my screen. Sorry. I almost forgot. Okay. So, Rita Gruber. I'm not going to be able to make it through all of them unless I just pick and choose what I'm uh, reading. So we'll say appellant Jacqueline Ferguson was convicted by a jury in the Lonoke County Circuit Court of second-degree domestic battering for physically abusing her child, LP, or I'm sorry, LF, who was 4 years old at the time. Let me make this a little bigger. Who was 4 years old at the time. You're forgetting that's what that's for. Okay, where was I? Oh. Appellant argues on appeal that the circuit court abused its discretion, first, for denying her motion to recuse from the case, and second, for refusing to accept her waiver of a jury trial. Because we hold that the circuit court did not abuse its discretion in either ruling, we affirm appellant's conviction. The issues before us in this case arose out of dependency neglect action, also on the Lonoke County Circuit Court. That case began after a call was placed to the Arkansas Child Abuse Hotline on March 31st, 2014, reporting that appellant had physically abused two of her adopted children. Why do people adopt children if they're just going to abuse them? What the fuck? At the time, appellant and her husband were serving as licensed foster parents. An adjudication hearing was held on July 1, 2014, at the conclusion of which appellant's children were adjudicated dependent neglected. Footnote 1. Appellant appealed the adjudication to the court, which affirmed because her argument regarding the judicial bias was not preserved. I'm not sure what that means. This is where I need Melanie. She'd know what that meant. But we'll go on. Okay, let's skip a little bit to okay. We can't really. At the adjudication hearing, the court heard the testimony of appellant's two teenage foster daughters, Dr. Karen Farst, a pediatrician from Arkansas Children's Hospital who specialized in child abuse pediatrics. Several lay witnesses familiar with the children who testified that the children had skin problems and allergies, and Dr. Brad White, a dermatologist who testified that marks on LF were consistent with a skin condition called urticaria. At the conclusion of the hearing, the court made the following statements. I find that there's dependent neglect. I do find that the allegations have been substantiated by proof beyond a preponderance of the evidence. The child is dependent neglect. There was physical abuse of the child younger than 6 years of age. I don't see how you can find anything else. In the meantime, on June 13th, 2014, the state filed an information for domestic battering against appellant in the criminal case. The judge who had heard the dependency neglect matter was assigned to this case too. On September 2, 2014, appellant filed a motion for recusal, arguing that the judge had presided over a juvenile case involving the exact same allegations that were involved in the criminal case and had quote, rendered decision against appellant in the juvenile court proceeding, end quote. Therefore, appellant alleged she should recuse pursuant to Rule 2.11a, B, and D of the Arkansas Code of Judicial Conduct, which requires a judge to disqualify herself in any proceeding in which her, quote, impartiality might reasonably be questioned, end quote, including circumstances where the judge previously presided as a judge over the matter in another court. Arkansas Code Judicial Conduct, Rule 2.11, 2015. Appellant also argued that the judge should recuse under Rule 2.11 A and 1, which provides as follows: the judge has a personal bias or prejudice concerning a party or personal knowledge of facts that are in dispute in the proceeding, i.e., appellant then waived her right to a jury trial. Or 1D, sorry. The circuit court held a hearing on both matters and entered an order on November 5th, 2014, denying appellant's motion to recuse, and an order on November 26, 2014, denying appellant's waiver of a jury trial. The court entered an additional order on February 3, 2015, indicating that she had denied appellant's request for bench trial and set a jury trial because appellant believed that the court harbored bias against her or had prejudice or had prejudged the disposition in the criminal case due to her involvement in the juvenile case. A jury trial was held on February 4th and 5th, 2015, where the same witnesses who testified in the juvenile hearing presented testimony. The jury found appellant guilty of second-degree domestic battering and sentenced her to 5 years in the Arkansas Department of Corrections, with an additional 1 year enhanced penalty for committing the offense in the presence of a child. Appellant immediately filed a motion for the setting of an appeal bond. The judge advised from the bench, "I do not do appeal bonds." On February 9, 2015, appellant filed a motion for reconsideration of the court's denial of her appeal bond, to which the state responded, in which the court denied in formal orders entered on February 24th and March 24th of 2014. Recusal. For her first point on appeal, appellant contends that Judge Elmore abused her discretion in refusing to recuse because she had presided over the same matter in another court. She had personal knowledge of the facts that were in dispute in appellant's criminal proceeding, and she exhibited the appearance of bias against appellant. We turn to the relevant law and our standard of review. A judge has a duty to hear a case unless there is a valid reason to disqualify. Moreover, a judge is presumed to be impartial, and the party seeking recusal bears a substantial burden in proving otherwise. A judge's recusal is discretionary, and her decision will not be reversed absent a showing of abuse of discretion. Finally, a judge's improper failure to recuse herself does not result in reversible error unless there is showing of prejudice from the failure to recuse. Okay. Just one second. Okay. I'm just gonna read the whole thing because there's quite a bit in here that is mind-boggling to me. Okay. Where was I? Okay. To support her argument, appellant cites the following authority found within Cayman 2 of the Arkansas Code of Judicial Conduct, which governs a judge's decision whether to disqualify in a particular case. A judge shall disqualify himself or herself in any proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to the following circumstances. The judge has a personal bias or prejudice concerning a party or a party's lawyer, or personal knowledge of the facts that are in dispute in the proceedings. The judge previously presided as a judge over the matter in another court. She argues that the judge presided over a juvenile dependency neglect action against appellant, and in the criminal case in which the exact same witnesses and testimony were presented against her. She also contends that the judge had already determined appellant's guilt before her criminal trial, as evidenced by her concluding statements at the adjudication hearing. There was physical abuse of the child, quote, there was physical abuse of the child younger than 6 years of age. I don't see how you can find anything else, end quote. Finally, she argues that the judge obtained personal knowledge of the precise facts in dispute in the criminal trial by presiding over the adjudication in which all of the allegations, witnesses, and evidence presented would be presented in the criminal trial. Appellant contends that bias was demonstrated by the court's refusal to accept appellant's waiver of a jury trial, despite the state's assent thereto. Its denial of appellant's motion for verdict, and its denial of appellant's motion for the setting of an appeal bond. Then I'll jump ahead to where she denied the waiver of a jury trial, and listen what she says to her. Appellant's second point on appeal is that the circuit court abused its discretion in refusing to accept her waiver of a jury trial after the state had assented to it. I don't know what that means. Appellant argues that she attempted to waive her jury trial and request a bench trial because she believed that she could receive a fairer trial by the bench. Arkansas Rule of Criminal Procedure 31.1 provides as follows, quote, no defendant in any criminal case may waive a trial by jury unless the waiver is assented to by the prosecuting attorney and approved by the court, end quote. The comment to that rule states that, quote, It is not the purpose of this rule to impose any limitations on a court's discretion to refuse to allow the waiver of a trial by jury, end quote. At the hearing on the matter, appellant's counsel admitted to the court that he thought the court might be biased against his client. The court then stated that it would deny the request for a bench trial and schedule a jury trial. Counsel indicated that he also had concerns about the jury pool in place, which was jury pool number 2. So the court agreed to use jury pool number 1 to alleviate counsel's concerns. In its formal order, the court denied the waiver, stating the appellant had questioned the court's impartiality and thus the case would be heard by a jury. An abuse of discretion occurs when the trial court makes a judgment call that is arbitrary and groundless. Smith versus State 90, Arkansas. Appellant's argument that she believed that she can receive a fairer trial by bench trial rather than by jury trial is in direct conflict with her motion to recuse and her counsel's statement to the judge that he thought she might be biased against appellant. A review of the record does not convince us that the court's denial of appellant's waiver was either arbitrary or groundless. Accordingly, we hold that the trial court did not abuse its discretion. So in that one, she won, but I mean, can you imagine saying, well, you think I'm biased, so you don't have the right to waive your jury trial. I mean, it's insane. Okay, so that was Nelson, right? Okay, so let's go. What's this one? Was I not sharing my screen again? I'm so sorry. God damn it. I promise I'll share it this time. I thought I clicked on it though, right? I clicked on it, so why wasn't it showing? Oh my gosh. Okay. Yep, you're right. I don't think I was. How do I get how do I move this over? No. So what I want, shoot. Okay, guys. Let's see. See, let's try this. And then I have that issue. How do I get rid of this stuff over here? That's what I'm gonna need to do. Then I'll be fine. Okay, we're gonna it's not working. Okay, so I got this stupid light in my face and I can't read anything. Okay. Let's try this again. Surprised I'm not muted. Um okay, I guess this is the best I'm gonna get. I think. Maybe not. Okay. Okay. Supreme Court of Arkansas. William Nelson versus State of Arkansas. Appeal from the Lonoke County Circuit Court. Honorable Barbara Elmore judge affirmed on direct appeal. Cross appeal dismissed. William Nelson was convicted by Lonoke County jury of first-degree domestic battery, for which he was sentenced to 8 years in the Arkansas Department of Corrections. On direct appeal, Nelson argues, 1, substantial evidence does not support his conviction, and 2, the circuit court's refusal to recuse was an abuse of discretion. The circuit court improperly denied his, what does that say? His Batson objection. I don't know what that means. The circuit court abused its discretion by limiting questions regarding sentencing during voir dire. The circuit court allowed inadmissible prior bad acts evidence to be introduced, refused to dismiss a juror for cause during trial, was an abuse of discretion. And 7, the circuit court improperly restricted expert witness testimony or alternatively erred by denying a motion to a continuance to obtain a new expert. On cross appeal, the state argues that circuit court misinterpreted this. God, my eyes are bad today. The stationary requirement to support the statutory requirement to support a sentencing enhancement and improperly granted Nelson's directed verdict motion on the issue. We affirm on direct appeal and dismiss the cross appeal. Okay, so we're just going to cover the part about the recusal. Okay, it describes the actual act, the case which got him arrested in the first place. On May 21, 2020, Chelsea Spadowski left her 2-year-old son, minor child 1, in the sole care and custody of her fiancé, William Nelson. Chelsea and Nelson lived together with Chelsea's son and Nelson's 1-year-old daughter, minor child 2. At some point that morning, Nelson allegedly heard a noise from MC1's bedroom and found MC1 lying on the carpet unresponsive. Nelson called Chelsea's mother, Tina Oguoski, who lived next door. Tina rushed to assist and found Nelson holding MC1's unconscious body at his back door. In the midst of trying to determine whether MC1 was breathing, she asked Nelson if he had called 911, to which he responded he had not. While waiting on emergency personnel, Tina told Nelson to rush MC1 to a neighboring nurse's home in hopes she could help. While Nelson was running with MC1 in his arms, a former police officer, Matthew Thomas, saw MC1's limp and lethargic body and immediately knew something was wrong. Thomas took MC1 from Nelson, rendered first aid to MC1, seized and waited with the family until the authorities arrived. MC1 was taken by ambulance to Arkansas Children's Hospital. Upon arrival, MC1 was quickly evaluated and promptly sent for a CT scan, wherein the doctors discovered he was suffering from a severe brain bleed or subdural hematoma that required immediate emergency surgery that bore holes in his head. Chelsea arrived at the hospital mere minutes before surgery, but in enough time to observe MC1 prior to his transfer to the operating room. She noted his eyes were fixed to one side, and he did not acknowledge her or recognize her due to his continued state of unresponsiveness. Chelsea observed MC1's apparent facial injuries and testified that her son was unharmed when she left for work earlier that morning. Because MC1 was taken to ACH with an altered mental status or abnormal level of consciousness, the emergency room physician notified Dr. Rachel Klingenpeel, a pediatrician who specializes in, quote, child abuse pediatrics, end quote. According to Dr. Klingenpeel's testimony, it is her job to evaluate for possible child abuse or neglect by applying the most current scientific evidence and knowledge to a diagnostic process to come up with the most accurate diagnosis that she can, end quote. Dr. Klingenpeel observed, these people and their names, observed, quote unquote, fresh bruises on MC1's forehead, redness on the back of the left thigh, and bleeding from his mouth due to a superior labial frenulum tear. So that's the little piece of skin that attaches your lip to your gum. That's the frenulum. You know, the taint, basically. That's what that is. That's what she's talking about. That was torn. And that'll bleed for a long time. So once in surgery, the neurosurgeon, Dr. Tomoko Tanka, found that a major tear in a branch of the large venous system was the cause of the bleeding, the source of the bleeding that caused the acute organized clot. Both Dr. Tanika, I don't know, and Dr. Klingenpeel confirmed without hesitation that MC1 would have died rather quickly without the emergency surgery. In Tinka's expert opinion, the cause of the injury was, quote, something very forceful trauma, end quote. Dr. Klingenpill's medical opinion on causation was significantly more detailed, as was justified by her unique expertise in the field. She testified that when a child has such a life-threatening head injury as MC1 did, quote, usually the cause is very obvious, end quote. A car accident, a high force trauma event, a fall from a substantial height, such as a multi-story fall, but not from tripping and falling at home. Ultimately, the complete lack of explanation. Oh, I didn't see a footnote, did you? Where's the footnote? Well, we'll read it anyway. Notably, the pathology results are significant to prove MC1's brain injury was from a very recent nature. Half an hour to a couple hours before surgery. Okay. Ultimately, the complete lack of explanation from Nelson as to how MC1 incurred such traumatic brain damage, combined with the fact that the subdural hemorrhage was not MC1's only injury. A variety of other injuries on multiple body surfaces existed, with, quote, each separate bruise or laceration representing a separate site of blunt force trauma to MC1's body, end quote. All contributed to her conclusive diagnosis of physical child abuse, including, quote, abusive head trauma, end quote. The state charged Nelson with one count of first-degree domestic battery and sought an enhanced sentence because the battering was committed in the presence of a child. After a 2-day jury trial, at the conclusion of the evidence, the circuit court granted a directed verdict and dismissed the sentencing enhancement sought by the state. The case was submitted to the jury, which found Nelson guilty of domestic battery as charged. Both Nelson and the state timely filed their corresponding appeals. Okay, that's sufficiency. In Nelson's first point on appeal, he argues the substantial evidence does not support the domestic battery conviction. In reviewing sufficiency challenge, we view the evidence in the light most favorable to the state, considering only the evidence that supports the verdict. Okay, I want to get to the part where she didn't recuse herself. The recusal of circuit judge. Nelson's second argument in the circuit judge Barbara Elmore, Judge Elmore, was required to recuse herself from the criminal proceeding because she had presided over the termination of Nelson's parental rights of MC2 in juvenile court. We review a circuit judge denial of a motion to recuse under abuse of discretion standard. So they basically Okay. In his written motion filed April 30th, 2023, just 2 days before the jury trial was set to begin, Nelson cites both the Code of Judicial Conduct and the concerning and concurring, notably not the majority opinion in a previous case decided by this court. Um, States that a judge shall disqualify himself or herself in any proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to the circumstance in which the judge previously presided as a judge over the matter in another court. Nelson claims that because the same allegations for his battery charge formed the bias for a petition to terminate Nelson's parental rights, and because Judge Elmore ultimately signed the order terminating those parental rights, Judge Elmore must recuse accordingly. And then it brings up the Ferguson case. He quotes the Ferguson as case law. It says, despite admitting that the majority holding in Ferguson does not stand for the principle that a dependency neglect proceeding and a corresponding criminal case constitute the same matter as require disqualification under the rules. Nelson nonetheless asks this court to extend its holding and mandate Judge Elmore's recusal in the case at hand. While the facts in Ferguson may appear to resemble those in Nelson's case, there are several key distinctions that make it distinguishable. Jacqueline Ferguson is a mother who was the subject of a child abuse investigation that ultimately led to a dependency neglect adjudication, terminating her parental rights, as well as a conviction for criminal charges based on those allegations. The adjudication, which took place prior to any criminal proceedings, was heard by Judge Elmore. As the sole fact finder in the DN case, Judge Elmore heard the testimony of witnesses and evaluated key evidence in order to reach her conclusion that the allegations were substantiated by the requisite proof. At the conclusion of the hearing, Judge Elmore stated from the bench that there was physical abuse of the child. I don't see how you can find anything else. In consideration of such, when Judge Elmore was subsequently assigned the criminal matter, JF filed for Judge Elmore's recusal, citing both Rule 2.11A1 and 6D of the Code of Judicial Conduct. In addition to denying JF's second recusal motion, Judge Elmore denied JF's jury trial waiver to alleviate JF's stated concerns that Judge Elmore could not be impartial and unbiased in a bench trial to determine her criminal liability. So, so, God, this is a long one. we might have to finish this either tonight or tomorrow because I'm about out of gas. I'm so sorry. I did not realize that these were going to be such long articles. Um, so what I'm going to do is I'm going to stop here, and hopefully you guys can find it in your heart to come back and let me finish this because there are quite a few cases that this has happened in where she refuses to recuse herself, and she was a judge in a case prior or a court case prior to the case that she's currently sitting on. And I don't care how small the county is, there's got to be other judges, and I just don't understand why she's on a power trip. She's like, you know, you know, you know what I'm trying to say. She's trying to pull it out and hang with the big boys. She's trying to prove herself, and I don't get it. Um, but ultimately, I think in this case with Nelson, it goes all the way up to the Supreme Court, and they reverse her decision and call for a new trial. So it's not like these allegations are unfounded, because they're not. And I just find it odd that it makes me nervous that she's on Aaron Spencer's case, because I feel like another Canoni is in the making, and I'm just like, the only thing missing so far is the I can't even think of the word, the corruption. And I'm not even sure there is no corruption, because this is the same state where the sheriff is being sued by an ex-female inmate for sexual crimes by the jail staff. So, yeah, there's that. I don't know. I feel like it just keeps getting worse and worse and worse. And I just pray for Aaron Spencer, and I hope you guys all keep him in your prayers. He is running for sheriff, and I think they're afraid of him winning, because I think he would put a stop to a lot of this, and he would be all over these people. I mean, heads will roll. He won't tolerate any bullshit, as he shouldn't. And the first people to go should be all these POSs that think that they are above the law, and that they're the only one, their opinion is the only one that matters. I mean, there are other judges that can try these cases. I think she needs to retire. I'm not impressed with any of her, with a lot of the decisions that I've seen, that I've read of hers, and I just don't get why they don't have to answer to somebody, why these judges have free reign to do what they please. No wonder they have God complexes, because they don't ever get told no or challenged, because they're at the top of the of the chain, so food chain. So who's going to question them? Same thing with the the under sheriffs, whatever they're called, deputies in Kentucky in the Steins case. I mean, that judge invited corrections officers, jailers, to come to his sex parties. And when she said no, he invited her again at another time. It didn't even faze him that she might report him. I mean, it's so blatant, and it's so irritating. And I just feel for these people that get caught in their web, because it feels like you can't there's no escape. And once you're in their sights, good luck. And if you don't have the money to fight it, you could end up in prison for the rest of your life, and it's infuriating to me. So, and I don't have his give, send, go information, but I will have it when I come back for the second part of this, I promise, so that you can donate to his defense fund and to help his daughter, to help his daughter continue with counseling. That's not cheap either. And I just hope that none of these counselors are related to any of the police or anybody involved in the case, because they're all related somehow, it seems like. That's bad. I shouldn't say that. But anyway, so I will see you guys either later on tonight or tomorrow, and we will finish this up, I promise, and I will be well rested. I don't work tonight, so I shouldn't have a problem getting some sleep, and I will be here. If I get some sleep tonight, I'll be here in the morning to finish up, but I'm hoping I'll be back tonight to finish it up. All I need is a couple hours, a couple hour nap, and I should be good to go. I don't require much sleep, which is kind of probably why I'm aging so fast. But anyway, and I don't work tonight, like I said, so I should be able to finish this up tonight for you. Hopefully you guys can come back and join me tonight. If not, I understand. But I hope that I'm improving enough for you guys to keep your interest and to make you want to stay with me through this journey that I'm taking. Okay? So that shall be it, and I will see you guys later on tonight. Okay? Thank you. Love you guys. Bye.